calling the case for Ms. Sejahrati Dursina and Government of Malaysia. Ready for appellant, Yang Arif?
Ready for respondent, Yang Arif.
So the appellant was arrested on 17 April 2002 under Section 73 of Internal Security Act or ISA, and her mother filed for an originating motion for following orders. First, that access be given to her counsel to take instruction from her pursuant to Article 5 Clause 3 of the Federal Constitution, and for that purpose the appellant be brought to court. And second, the appellant to be released under the writ of habeas corpus. But during the period of trial, the appellant was still detained. However, on 12 June 2002, the High Court fixed the case for its decision on 14 June 2002. But on the same day, the minister with the power vested to him by Section 8 Clause 5 of ISA issued a restriction order, and the court only learned about this on the judgment date and dismissed the application, which brings us to the appeal today. So the court decided to hear the argument whether the appeal was maintainable in the view of the fact that the appellant was no longer under detention. Now we will hear the argument from the appellant counsel.
Much obliged, Yang Arif. My name is Revdi Devatidan, and today I am representing the appellant, Ms. Dursina. This case concerns the unlawful detention of the appellant under the Internal Security Act. We argue that her fundamental liberty under Article 5 has been violated. Even though the appellant was placed under a restriction order, she was originally detained, and that detention must still be examined by the court.
But counsel, the appellant was no longer physically detained, so how can the writ of habeas corpus apply in this case?
Young Arif, that is precisely the problem. If the authorities can simply change a detainee status at the last minute, it renders the entire application meaningless. This creates a dangerous loophole. The executive can avoid judicial scrutiny by switching from detention to restriction just before judgment. The relevant date should be when the case was heard. Otherwise, the executive can manipulate timing to defeat legal challenges. The court should hear the appeal on all grounds that are raised due to several questions that needs to be satisfied. 1. The personal liberty of a person. Second, points of constitutional law. Article 5 Clause 2 of the Federal Constitution provides where complaint is made to a high court or any judge that a person is being unlawful detained, the court should inquire into the complaint, and unless satisfied that the detention is lawful, shall order him to be produced before the court and release him. In the case of Muhammad Azam bin Muhammad Noor against Ketua Polis Negara, the court went to a land and issued with the writ of habeas corpus and ordered release of detainees despite the detainees not being held physically in the custody of the police. We also submit that issuing the restriction order during proceedings interferes with the administration of justice. The minister, in issuing the restriction order, commits contempt of court because by doing so, he prevents the court from deciding the case.
Thank you, appellant counsel. So, respondent counsel, please present your argument now.
Yes, Yang Arif, I'm Joanne Vanessa Andrew, and on behalf of my client, I represent the government of Malaysia. I want to highlight that the law is very clear. A writ of habeas corpus only applies to actual physical detention. Yang Arif, Under the Article 5, Clause 2 and Section 365 of the Criminal Procedural Code, the court can only order one remedy, which is the release. However, this can no longer apply to Ms. Sejaratu.
And your point is?
Yang Arif, the appellant is no longer detained. She is already at liberty, albeit with restrictions. Therefore, the court cannot release someone who is not in custody. The application is nugatory. If the court refuses to hear this case, it allows the authorities to bypass justice entirely. Yang Arif, the court's jurisdiction depends on actual detention. Once detention ends, jurisdiction ends. This is supported by precedent. A restriction order is not the same as detention. In the case of Rey Ongkar Shriyan, a judgment of High Court Singapore, the Judge Chur Singh Justice dismissed the application on the ground that a person at large on bail is not detained in custody so as to be entitled to the writ of habeas corpus, which is issued only when the applicant is in illegal confinement. So, the writ of habeas corpus is only available to a person who is being physically detained unlawfully. He must be in actual custody. This issue is also answered by the Supreme Court in the judgment of Chew Song Chin, Supra. In that case, orders had been made under the Restrictive Residence Enactment, requiring the appellant to reside in the town of Gua Musang for a period of 3 years and to be placed under police supervision for the same period. The appellant applied for a writ of habeas corpus to challenge the orders made against him, however, was dismissed by the High Court. The appellant appealed to the Supreme Court and it held that the restraint did not constitute detention that suffices writ of the habeas corpus. The writ of habeas corpus was therefore not available to the appellant in the circumstances.
Thank you. Now, Appellant's Counsel, please present your rebuttal to the respondent's argument.
Yes, Young Arif. Despite the traditional interpretation of Article 5, Clause 3, we argued that it is a narrow interpretation of the clause and thus limited fairness in this case. The material date, which is the date that should be focused here, was the date when the case was heard. We must examine the legality of detention during the date rather than simply dismissing the application just because of the change of the status before the date of judgment.
Yang Arif, the law recognizes that the hearing includes the date of decision. If the situation changes before judgment, the court must consider the current facts.
Young Arif, I plead for the court to examine thoughtfully the facts that Ms. Sejaratu had been detained for 3 months before the order of restriction. The recent change of status shouldn't impair fairness, and the minister had done an act which can avoid him from legal consequences.
So, do you mean the minister is trying to manipulate the law for his own favor?
Young Arif, the action of the minister is what makes the application of habeas corpus by the appellant dismissed despite what she would been through for 3 months prior.
Rebuttal from the respondent's counsel.
Young Arif, the argument likening the act of the minister to contempt is unfounded. This situation is no different from a prosecutor withdrawing charges during trial. It does not amount to contempt. The appellate counsel preached for fairness, yet it was illogical to seek action under Article 5, Clause 3 of the Constitution because it was stated clearly that it meant to release a detained person. A person who is already at large doesn't apply to this.
The appellant is still restricted under the restriction order of Section 8 of Internal Security Act.
And the restriction doesn't amount to detain. As I've explained in the precedent case of Chu Song Chin, where a house restriction is not what sufficed under Article 5, Clause 3, nor Section 365 of the Criminal Procedure Code. I repeat, Young Arif, what the appellant counsel seek is noble. Yet how could it be realized when the elements and the nature of this case clearly doesn't amount to the law and the release of the habeas corpus?
Having heard both sides, the court finds as follows: that the only remedy that can be applied under Article 5, Clause 3 of the Constitution and the Section 365 of the Criminal Procedure Code is habeas corpus and nothing else. The writ of habeas corpus applies only to actual physical detention, and since the appellant is no longer under physical detention, then the court cannot grant the remedy of release. The application is no longer maintainable. On the issue of the material date presented by the appellant counsel, the court holds that it includes the date of decision, not merely the hearing date. And thus, if the appellant had already been released from her detain, there is no need for writ of habeas corpus to release her anymore. As for the allegation of contempt, the court finds it without merit and preposterous. What the minister had done may be controversial, however, it is not amounted to contempt and it amounts only to withdrawing charges, and that is not contempt. Accordingly, the appeal is dismissed. Court adjourned.